You're listening to Radio VR, the voice of Russia in London, with me, Juliet. For the first time in British legal history, barristers and solicitors walked out of courtrooms across England and Wales in January in protest over government cuts to legal aid. The Justice Minister, Chris Grayling's proposing to slash £220 million from the annual £2 billion legal aid fund. This pays for court representation and other services for those who cannot afford it. Some barristers say the proposed cuts of between 17 and 30% could see their average earnings fall beneath the national minimum wage, which is currently £6.31 an hour. But the Ministry of Justice says efficiencies are necessary to ensure legal aid remains sustainable. Recent figures published by the Ministry of Justice shows that more than 1,000 barristers working full-time on taxpayer-funded criminal work received £100,000 each in fees income last year, with 6 barristers receiving more than £500,000 each. So joining me for a discussion about the legal aid cuts is Professor Stephen Mayson, Professor of Law in the Centre of Ethics and Law at University College London, Wendy Pettifer, Solicitor at Hackney Law Centre and legal aid lawyer, Harry Mount, a former barrister, author and journalist for The Spectator, and taking part on the telephone is Rachel Knowles, who's a senior education community care solicitor at Just for Law Kids. I'm going to ask you all in turn, what legacy will the cuts to legal aid have on Britain's legal model of criminal justice? I'm going to start with you, Wendy. What do you think?
I think that over the years the cuts have meant that legal aid ceases to be easily available for the most vulnerable members of our community. We should remember that the Transforming Legal Aid Bill, about which there's recently been a lot of publicity, is just the end of a long line of cuts. I'm a civil lawyer. I specialise in housing and homelessness cases, and the LASPO cuts, that's the Legal Aid Sentencing of Prisoners and Offenders Act 2012, those cuts already came into force in April 2013, and they led to taking out of scope assistance for benefit cases, for housing cases, unless they involve possession proceedings that have already been issued, or actual homelessness, and a number of other areas about which I won't discuss. The current proposals, I think that as a civil practitioner, my principal concern is the removal of legal aid for judicial review proceedings after permission has been granted in an application in the administrative court. I and my colleagues use judicial review frequently in order to challenge decisions by both national and local state, and this removal will mean that we can't do that. For example, I frequently demonstrate a strong case to argue in the administrative court by obtaining initial legal aid to pay for a barrister's opinion and the drafting of grounds, which are then sent to the other side, and the case settles. The client, who's usually destitute, gets support and accommodation, often from social services. This won't happen anymore, and that's a great concern to us. The other concern in the new bill is the requirement that all applicants for any form of legal aid have to demonstrate both that they're lawfully present at the moment when they ask for legal aid, and they have been so for the last 12 months. Many of our clients are lawfully present but don't have the documentary evidence to provide proof of that. For example, I've taken on a case this week of a British woman of Nigerian origin with 2 British children who's homeless, and already, before Transforming Legal Aid is fully enacted, the local authority has told her they won't assist her because her British passport is 10 years out of date.
So, in lay terms, what legacy is this having on the clients that you work with?
I would say that the legacy means that our right, which is enshrined in the British justice system, to offer constitutional safeguards to hold the national and local state to account, and which is judicial review is the means by which the judiciary can scrutinise those rights, whether it's the recent case of the 10 fire stations that challenged Boris Johnson's decision to close them down, or whether it's an individual who has been denied access to housing as homeless in certain circumstances. That right will go. So there will be no easy, available public scrutiny of decisions by the local and national state, and decisions will be made with impunity. For example, the removal of legal help to provide support for benefits appeals means that the decisions go unchecked. Really, a first-tier tribunal judge can make a decision which isn't lawful, and the claimant, who is often disabled, will have no ability to challenge that decision and no ability ultimately to challenge it in the public arena without representation. They're incapable of doing it by themselves.
OK, I think I'll come to you next, Rachel Knowles, Senior Education and Community Care Solicitor, on the legacy that you see, the cuts that have been taking place and the sort of final announcement that it has on the people, the clients, the children that you work with.
Well, I can only agree with everything that Wendy has said, and I think it's just very simple that if these cuts that are being proposed are passed, vulnerable children are going to be denied access to justice. There's no two ways about it. The children that I represent at the moment, they're still able to get legal aid, but if the residence test is passed, it will be virtually impossible for, I would say, a good 50% of my clients to be able to access legal aid. I represent children who are homeless, who've been kicked out of their parents' homes, or who don't really have any relationship with their families anymore. And to expect a 16 or 17-year-old child to be able to demonstrate lawful residence when they don't even, have a penny to their name or a roof over their head is just, it's an absurd requirement which children are going to really, really struggle to be able to show. I had a client recently who was fleeing domestic violence and physical abuse from her parents, and she did have a British passport, although she was of a different nationality origin, and her parents withheld her passport from her, and she wasn't able to access it. And even though she attended her parents' home with a police escort to try and get it, she still couldn't get her passport to demonstrate that she was a British citizen and was lawfully resident in the country. I can imagine there'll be many, many more cases like that. I think the people who are going to suffer are the children, the vulnerable people, the people who have mental health difficulties, and certainly not people who are able to pay for a lawyer. They'll be fine.
You're listening to Radio VR, the voice of Russia in London, and I'm joined by Professor Stephen Mayson from the Centre of Ethics and Law at University College London, Wendy Pettifer, Senior Solicitor at Hackney Law Centre, Harry Mount, author and journalist and former barrister, and Rachel Knowles, Senior Education and Community Care Solicitor at Just for Kids Law. There's two aspects of this case of the legal aid cuts which is covered in the media, and it's one of which is barristers losing money, and one that necessarily isn't covered all the time is the effects it will have on the most vulnerable in society. Next then, Professor Stephen Mayson, as an overarching view then on the legacy of these legal aid cuts, what do you think?
I'm not sure we know at the moment what the legacy will be. There's a lot of talk, largely driven by either the personal finances of the lawyers or the politics, that are polarising the argument between we lawyers aren't earning enough and we're fearful that clients won't get the representation they need, and a state which is saying we can't afford it. We cannot afford the open-ended commitment that the original principles of legal aid more or less enshrined in the system. So I think both sides are in some difficulty. I'm not sure either is necessarily the outcome or the legacy that we will see or would want to see. The things that drive it, I think, are not being talked about at the moment. And what we have probably is an excess of politics and an absence of policy. If we're going to square this very difficult conundrum. We've got, I think, to go back to some basics and say, what is it we should be funding and for whom, and how much can we afford to do that? And I think one of the desperate challenges we have at the moment is that there are so many rights that exist, which many of them are created for the needy and the vulnerable in society, but they can't afford to enforce them. And we seem to have a bit of a mismatch between that volume of rights that ought to be available and ought to be pursued, and the funding available to the vulnerable to pursue it. Clearly, in current economic circumstances, it's incredibly difficult to get the two to match up. But I think for the government to fight this on an efficiency argument, i.e. too many lawyers, they need to be more efficient, we need bigger units of lawyers, and only to fight it on that basis, which is largely where I think the argument's coming from, doesn't seem to me to get us much further. But for lawyers to fight it on the basis that we're now earning a lot less than we used to, and we can't afford to stay in practice, might be true. No matter whether the argument's right or wrong, it might be true. But I don't think it's one that's going to be garnering a lot of public support.
Harry Mount, I've asked everyone about the legacy, and you wrote an article saying, Chris Grayling's right to be reforming legal aid. Where do you feel that the legacy will be for the cuts to legal aid, and what do you think?
Well, I can't speak as expertly as the previous speakers on the actual effects, because I'm no longer a barrister and I didn't deal with those claimants having a rough time. So I defer to them, and undeniably, if you cut, there will be suffering as a result of that, and that's regrettable. But as Stephen said, we're not living in an ideal world. In an ideal world, you would have infinite resources to pay for infinite lawyers. Given that we don't have those infinite resources, you have to make cuts, and I'm not sure the cuts are being made in the right place. But I do feel very strongly, as a former barrister, that you can make cuts without making those terrible effects. That I think you'd have to do it by reforming the system. In my time as a barrister, I was struck by the incredible overmanning of the legal system. So in a single case, you might have a solicitor who deals with the beginnings of a case. They will then have a conference to explain that to a barrister, while the barrister picks up the basics of that case. If that case is then taken on, you might have the solicitor, a junior barrister, a silk or a QC, all in court together, all for multiple defendants. And if you go along to a court case, as the public can, you will see a court largely packed with quiet people, lots of them doing absolutely nothing, being paid not always a fortune. I see that a lot of criminal barristers I accept are being paid a pittance, but you'll be seeing a lot of people being paid a fortune in public money. And the answer, I see it, is to reform the system. I think the division between the solicitor and the barrister should go. I think it's ludicrous to have this strange anomaly of something called a QC who gets to wear a different sort of gown, who therefore is paid even more money, and you have this duplication, triplication in some cases of representation. I thought there was a quite shocking letter last summer in the Telegraph from 90 QCs complaining about cuts to judicial review, which you can talk about the amount of cases, and they have rocketed in the last 40 years. There were 160 judicial review cases in 1974. There were 11,000 in 2011. Now, I'm in no position to say which of those were virtuous, which weren't, but I think you should have some restriction on those. And beyond that, those barristers, those QCs who are complaining about the cuts to judicial review, never for a second suggest, these are senior barristers earning in excess of £100 an hour, I'd say on kind of £400 an hour each. They would never say for a second, in order to serve the higher justice, I will take a cut in the massive amount of money I'm being paid. So I think you just have to reform the legal system in this country wholesale.
They might not want to take a cut themselves, but I don't think you could deny they might have a feeling that the future barristers of this country are having a really tough time, and those who want to continue to practice in criminal courts are going to have to make difficult choices. Wendy, you've been writing furiously there.
Well, I would agree that QCs are paid far too much money, and I think that the the bar does need to be reformed. I would agree with that. But I would say on that point that, as far as I know, junior counsel in the lower courts, in the magistrates, are paid £45 per case. If they're lucky, they'll get 2 cases a day, one in the morning and one in the afternoon. So if the 17.5% reduction that's in transforming legal aid comes in, that will go down to £31.50.
I agree with you. I'm saying at the lower end, there's something going wrong there, but you need to reform at the top end.
I would agree that
system,
reform at the top end is needed. But on your point of over-representation, if we just look at the Duggan inquest, which took place last week, there were 6 QCs at that inquest, all publicly funded, but only one, Mike Mansfield, funded by legal aid. Now, I would say that cuts can be made in other areas. There was no need for the police, who are funded through the Metropolitan Police, through our council taxes, to have 5 QCs.
I completely agree. I consider legal aid just a part of public money. It's the same problem.
But
There's a massive splurging of public money.
Is about legal aid.
Sure, fair enough. Yeah.
And if we look at costs, I'm a housing lawyer. I'm in the county court every week. I'm on the duty possession list. And I think that the cuts in the availability of both legal help and now we're looking at legal aid for people facing homelessness, increases public funding expenditure. Court lists are getting very long, partly because there's more and more litigants in person, so extremely well-paid county court judges are having to take more time on their cases. More people are being made homelessness because preventative work isn't being taken to ensure that their finances are in order and they're claiming housing benefit that they can at the moment claim, and then the cost goes back to the local state. There was somebody on the radio this morning talking about the lack of doctors in A&E who said quite rightly that there's a clog up in hospital beds all the way down the line because of social services cuts. People can't be discharged, particularly cases that I act for, people who've been in voluntary mental hospital, because social services have no money to pick up the tab and accommodate those people. Now, we're challenging social services by way of judicial review at present to require them to accommodate, and in a way it is a crazy waste of public money. The money needs to go back directly to the social services so those challenges via legal aid aren't made.
You're listening to Radio VR, the voice of Russia in London, with me, Juliet Spare, and I'm joined by Professor Stephen Mayson from the Centre of Ethics and Law at University College London, Wendy Pettifer, Senior Solicitor at Hackney Law Centre, Harry Mount, author and journalist and former barrister, and Rachel Knowles, Senior Education and Community Care Solicitor at Just for Kids Law. This discussion about legal aid seems to shine a light on other aspects that aren't necessarily being talked about. And you mentioned, Professor Mayson, that, it's a lot of politics, a lot of personal finances. What do you want to see being talked about?
I think what we need to talk about is if, as a society, we're going to create rights for citizens, and particularly for vulnerable citizens, what are we also going to do, and what are we therefore going to pay to allow those rights to be exercised? Because if the rights are created and there is no route to enforcement, then there's no point in the rights. You're destroying the parliamentary and legislative intention that lay behind the creation of the rights in the first place. I therefore think we need to go back and look at what gives rise to the need for the rights. And in some cases, taking the judicial review issue, it is because certain public authorities are not doing their job effectively enough and using their budget to do the right thing. And putting it right is then not falling on their budget necessarily, but the legal aid budget. And suddenly you have a Ministry of Justice that's looking for cuts in expense that probably ought not to have been there in the first place, irrespective of how much you pay the lawyers to pursue those rights. So I think we've got to find some way of rebalancing the rights we create and how we enforce them and how we fund them. And one of the added difficulties in all of this is that very often the rights that are created for the most vulnerable involve some of the most technically complex law or the most contested human situations, and they can't be dealt with as part of a volume process, as part of some efficiency model. They do need very careful consideration, sometimes years of experience and training. And then, therefore, we can't afford to take a blanket approach to saying, well, we've got to slash the rates we pay all lawyers because we can't afford it. So I don't think we're having a graded argument about the creation of rights, the enforcement of rights, the funding of those rights, and the rewards that we pay to those who are absolutely needed to enforce them.
Rachel Knowles, obviously your input is gratefully received. My interest in the cuts to legal aid, I think, began when a QC did explain to me that she felt that the victims, the children, are in cases such as sex grooming, will be left more vulnerable because they'll be represented by more inexperienced barristers and solicitors. So coming at it from a victim's perspective, I asked Stephen Mayson, the arguments are there about personal finances and lawyers and politics. Where would you like to see the argument going?
I think everyone's raised some already very good points about kind of making these cuts to legal aid without considering other places and other ways that funding can be cut. I certainly agree that there's scope for cutting barristers' fees at the QC level. But I also think that, one of the things that I found very frustrating is that every time the cuts are being justified by the government, they always start by saying we have one of the most expensive legal aid systems in the world or in Europe, or one of those sorts of expressions that they use. And actually, when they're looking at the cost of the legal aid system, they're only looking at the cost of the barristers, and they're not looking at the costs that incurred by the court system, by the judges, and the kind of more general cost of the court service. And if you cut costs to barristers, what's going to happen? And there was a judgment relatively recently by Mr. Justice Wards in the Court of Appeal case where he's made it very clear that in cutting legal aid to barristers and for lawyers and for claimants more generally, all that's going to happen is that cost is going to be reflected in increased litigants in person and an increased cost on the court system. And the cost to a court system for 3 Court of Appeal justices listening to a case with a litigant in person on either side is enormous. So, in comparison, paying a junior barrister £45 for a hearing seems like a pretty good deal to me.
There's also the argument I hear that, Britain has a legal system that is envied around the world, and people choose to litigate in this country because of the high standards of advocacy. And what do you think about that, Harry? Do you think that this will there are a short-sighted view that to cut our system and make it less attractive to other people from other countries coming to litigate here?
No, not particularly. I think lawyers here are fine, but I think a strange myth has emerged, partly thanks to Rumpel or the Bailey, Charles Dickens, a million legal dramas, that lawyers, barristers in particular, are somehow these supermen who are absolutely brilliant intellectual colossuses, if that's the right plural. Colossi. And like any, it could be colossi, like any profession, you get some good ones, you get some bad ones, you get a few excellent ones. Same way you get good and bad journalists. But a legend has emerged that they are all, or largely all, brilliant. Most of them are fine. They're average. They're not brilliant. The stuff they do, particularly in more simple work like criminal and family work, is incredibly straightforward. You don't need to have a first from Oxbridge to do it. You don't need to be paid £400 an hour to do it. So you could run most of the legal system of Britain much more cheaply without paying people the fortune that they're supposed to earn because they're supposed to be such intellectual giants. So there was a great hoo-ha about opening up. I think this has been stopped. Legal aid to Eddie Stobart, the lorry company, as possible tender to provide criminal solicitors. Now, this immediately shocks people because they think how appalling to apply commercial questions to legal issues which are so important. But no one thinks that about supermarkets, that competition is a bad thing. The idea that because you make something competitive it's going to get worse, I don't think is true. And a lot of the law that's being carried out is extremely simple and could be done much more cheaply.
Would you agree there, Professor Mayson?
I certainly agree in principle. I've spent most of my professional lifetime trying to get lawyers to think more like business people and to think about the economics of what they're doing and competing effectively. It is often polarised into profession versus business rather than profession and business, and there's no evidence that business people are inherently ethical. And unfortunately, there's an awful lot of proof that not all lawyers are ethical either. So if you polarise the debate into profession versus business or ethics versus not ethics, I don't think we get terribly far. So I do think we have to look at the efficiencies with which legal services are delivered. We have to look at overmanning. We have to look at what level of qualification is needed for certain types of services and whether any of it can be subject to process rather than individual craft. On the point about whether our justice system as a whole might be compromised by this, I think there's an important difference here. Those in other parts of the world who choose English law as their law of choice so they can litigate in English courts if things go wrong, generally are not going to be looking at legal aid, and they're not going to be looking at that part of the legal profession, whether solicitor or barrister, that deals with legal aid cases. So I don't think this in itself threatens the global supremacy of English law and English legal system. If there's a thin end of a wedge, it is that you undermine the professions that support that you in some way undermine the courts that enforce it, and that over time, but I think it would be a very long period of time, we might upset the fabric of the administration of justice in this country. But I think from where we are today, that's a very long-run argument, and I don't think there's an awful lot of evidence that would support it.
Wendy, to come to you then, picking up from that, would you feel, or do you think, thinking about the economics of it means that we miss the argument of thinking about the vulnerable, the voiceless and the victims who, through shining a light on this discussion of legal aid, you see the other effects this is having on society in Britain today?
Indeed, I do agree that the discussion is skewed far too much by concern of how much lawyers are paid. As a point of clarity, having been a practising legal aid lawyer all my life, I earn £34,000 a year, and I'm doing top-end work in the administrative court, up to the Supreme Court, actually. I took a 20% cut when I left the University of Law to go back into practice. And many, many legal aid lawyers, solicitors and lower-level barristers are earning similar amounts of money. To just pick up on a couple of other points, in terms of comparison with European systems, the comparators are skewed because they're compared with inquisitorial rather than accusatorial systems. I'm a French speaker and have lived in France, and there a lot more money goes into the court system rather than into paying individual lawyers. And I would finish by saying that I first worked in Manchester Law Centre in the 70s. I wasn't qualified then, when a film called Cathy Come Home was made. I think it was in 76, and it tracked the descent of a single parent into poverty and homelessness. As a result of that film, the first homelessness legislation came onto the statute book. It was the 1977 Homelessness Act, which initially imposed a duty on local authorities to provide accommodation for the homeless if they're unintentionally homeless and in priority need. We've come a long way since then. We've had the incorporation of human rights by the 1998 Human Rights Act, and from my point of view, I can see us hurtling back to the Cathy Come Home days. I don't want that to happen. I don't want to be acting for women with small children who are living on the street.
That was Wendy Pettifer, Senior Solicitor at Hackney Law Centre and legal aid lawyer. And I'd like to take this opportunity to thank all my guests. Professor Stephen Mayson, Professor of Law in the Centre of Ethics and Law at University College London. Harry Mount, former barrister, author and journalist, and Rachel Knowles, Senior Education and Community Care Solicitor at Just for Kids Law.